There it goes. So we look like we're ready. So I'm going to turn it over to the judges and good luck.
Good afternoon. Welcome to day 2 of the Nationals. Congratulations. I'm Mark Simons. I'm an attorney that practices law in the state of Nevada. And my co-judges are tired of hearing this, but I keep telling you, you can make money doing what you're doing. People will pay you to talk. So stay engaged, stay focused on this. I'm excited to hear what you have to say. My other judges will introduce themselves, then we'll ask you to introduce yourselves, and we'll read the question. You can begin. Thank you.
Good afternoon. I'm Karen Milton from New York. I'm a lawyer by training. I'm currently the Chief of Staff in the Inspector General's Office for the Metropolitan Transportation Authority. That's the state agency that oversees the New York City and Greater New York transportation system. Prior to that, I was the Circuit Executive for the Second Circuit, overseeing the 13 federal courts in the states of New York, Vermont, and Connecticut, where we actually talked a lot about habeas corpus. So I'm really interested and thrilled to be returning to a discussion on the Great Writ, and I look forward to hearing from you.
My name is Charlie Hinderleiter, and I am not an attorney. I'm the Director of Government Affairs at St. Louis Realtors in St. Louis, Missouri. I am a past political science professor, and many moons ago now, I was once a student in the We the People program on the other side of, thankfully you actually have a table so I can use this metaphor, on the other side of the table. So I'm looking forward to our conversation and having some fun today.
Can you introduce yourselves, please?
I'm Tyler Huber.
I'm Madigan Schmitz.
I'm Diane Glassford.
I'm Noah Friedrich, and this is our teacher, Mr. Gainey.
All right, here's what we're gonna do. We're gonna have question 2. Once I read it, take a deep breath and then begin when you're ready. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government?
In the aftermath of the English Civil War, the first exclusion parliament met after the dissolution of the Cavalier Parliament in 1679. Most notably, they passed the Habeas Corpus Act of 1679, primarily out of fear of the potential arbitrary rule of the king, in particular, the Roman Catholic Duke of York, who was in line to take the crown. Habeas corpus comes from the Latin words meaning "you shall have the body." That is, a judge or court must have the body of a detainee brought before them to hear what they are being charged with. The major limitation that this puts on the government is the inability to indefinitely detain a person without knowledge of accusation. Founding fathers assume understanding of habeas corpus, never directly defining it in the Constitution. The only mention of habeas corpus is in Article 1, Section 9, Clause 2. The privilege of the writ of habeas corpus shall not be suspended unless in cases of rebellion or invasion of the public safety may require it. As to what these two cases are, depends upon the Supreme Court's ruling. Habeas corpus is indirectly mentioned in the Sixth Amendment, which states, quote, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, and to be informed of the nature and cause of the accusation."
Habeas corpus is necessary for the principle of limited government, which is a restriction of legalized arbitrary power and force. Habeas corpus is crucial to this principle in the way that it helps to prevent unlawful imprisonment and acts as a check on the legal system. In the same way that the branches of government serve as checks and balances for one another, habeas corpus further prevents the executive branch from having too much power over the people, in particular agencies that have the power to imprison, such as the FBI, CIA, and IRS. We can see what would happen without a habeas corpus by looking at Guantanamo Bay. Until the 2008 court case, Boumediene v. Bush ruled that detainees can challenge the lawfulness of their detention by filing a writ of habeas corpus. Detainees were subjected to indefinite detention. Without a habeas corpus, a government is able to arbitrarily use its power and force.
The writ of habeas corpus is a cornerstone of the American judicial system. Every person should be entitled to a free and fair trial. As Noah stated, habeas corpus can't be suspended except for in instances of rebellion or invasion. Under no circumstance should the right of habeas corpus be suspended unto death. However, in the interest of protecting threatened groups and people, there are times in which the suspension is necessary for the greater good. In situations where the public safety is threatened, the general welfare should trump due process, such as in cases of biological warfare or terrorism. With that, habeas corpus should never be suspended without the objective of holding a trial. Although being foreign nationals, prisoners held in Guantanamo Bay have no hopes of ever receiving a fair trial. While the crimes they committed were heinous, holding them in prison indefinitely with no trial is inhumane in and of itself, and a violation of the Geneva Convention. In certain situations, holding a trial for an individual or group may be a grueling and lengthy process, but habeas corpus should by no means be suspended without the ultimate goal of holding a trial.
The first time that the writ of habeas corpus was suspended was during the American Civil War. Since then, it has been suspended multiple times directly and indirectly. The writ of habeas corpus has been suspended 4 times in the United States directly. The reasons for these suspensions have varied from the KKK in South Carolina to Japanese Americans in Kuromatsu v. United States after the bombings of Pearl Harbor. The writ of habeas corpus has evolved in the United States and throughout the world after World War II. After this war, the idea of habeas corpus was upheld across the globe by the Geneva Conventions. Yet there are still issues with how, who, and where the writ applies. For example, the writ of habeas corpus and the rights that it provides are still not given to those detained in Guantanamo Bay, with numerous court cases for and against the camps. In the United States, we like to think that this writ helps give citizens more of a fair trial to ensure that their rights are not infringed on, but this is not the case for all. We are now ready to take your questions.
Thank you. So walk us, if habeas corpus, what other parts of the Constitution protect people against arbitrary incarceration? I mean, you have a Bill of Rights, as you noted. I think you mentioned the 6th Amendment. You referred to the 8th Amendment, cruel and inhuman punishment. So why do we need habeas corpus if we have a written Constitution and a written Bill of Rights?
Well, as far as why we need it, is because it was at first mentioned before the Bill of Rights was implemented. Like I specified in the article of the Constitution, it is specifically mentioned in the Constitution, and the Constitution was ratified prior to the Bill of Rights being written. So I think that is primarily the reason that it's still there, and due to the difficulty of changing the text within the Constitution itself. Obviously, hasn't been any direct changes to the text in the Constitution. There's only been things tacked onto the end, that is the amendments. So everything that was added on the end was afterwards, so they just simply left the article involving habeas corpus.
And I would say, in terms of protections that are already within the Constitution, I would look to freedom of speech. When habeas corpus is suspended, rights are already being violated. So I think the ability to be able to use your voice in order to protect yourself is one of the most important things.
All right, let's pivot to the historical context. Would you evaluate President Abraham Lincoln's suspension of habeas corpus during the Civil War? Do you think he was right or wrong to do that?
I personally believe that he was correct in his decision. Washington, D.C., due to its location, was surrounded by states that either supported secession or had legalized slavery, including Maryland and Virginia. And due to his location being surrounded by enemies, he had to have a solution to the impending threat from all around him. And also the cause that was being fought for in the Civil War was unquestionably justified, unlike a lot of causes that the writ of habeas corpus has been suspended for, such as Japanese internment and Guantanamo Bay. It is significantly more difficult to argue against the Union side of the Civil War than it is to against those things.
All right, can you explain to me or rationalize if state governments are impacted by the habeas corpus requirement? And if so, how?
I would say that they're impacted on, it's kind of a case by case basis, because I feel that there are times when it should be suspended, but it should never be suspended without the ultimate goal of holding a trial eventually. I don't think people should be able to be held and detained for years and years on end. But I do feel there are times in which it could place a burden on state governments. And that would just look to an amendment within the habeas corpus. But as a whole, I think that there is reform that needs to take place. But yeah.
I would say, I had to think about that for a second there. When you take into consideration instances of insurrection directly within the state or anything like that, a previous group from our school was just saying earlier that the Constitution is the baseline, and then they can add more laws, but they can't take away laws. So obviously, the states aren't allowed to take away a significant portion of laws. So they have to obey the article that specifies the writ of habeas corpus shall not be suspended. But if there's something happening inside that state and they're needing to quickly resolve it, and the federal government isn't willing to suspend the writ of habeas corpus, then I can understand that that would cause an issue for that state specifically.
I would say another way that this relates to state government was the 3 strikes law in California. It was Lockyer v. Andrade, I believe, that they ruled that nobody is able, or that they weren't able to petition for writ of habeas corpus, and then they also ruled that it was not in violation of the 8th Amendment for the 3rd strike.
So I'd like to go back a little bit to sort of what, if you think that habeas corpus places a burden on state governments, what amendment would you propose, to make it easier for the states to deal with habeas corpus? I mean, today, habeas corpus petitions are generally filed by state prisoners after they've exhausted their administrative rights, and then they come into the federal court system. So what do you think we need to do to make to ease the burden of habeas corpus on the state governments?
I feel like the only burden that it puts on government is like the time that it takes to deal with all these writs of habeas corpus being filed. And the best way to go about fixing that is just to have a bigger agency that looks at the habeas corpus and more people working on each case.
Considering what I said earlier, it reminded me of the suspension of habeas corpus, specifically of the KKK in South Carolina. That was a state only, so that would only apply to the state of South Carolina with permission of the federal government, and that was to deal with members of the Ku Klux Klan who were suppressing voting, whether or not they could have actually been found guilty of that crime. They could still have been detained simply due to their affiliation. So I think that while there is potential for it to cause an quote unquote unreasonable burden, I think that for the most part in history it hasn't. So I don't think that there needs to be significant change yet.
All right, so you've clearly identified habeas corpus as one critical tool for limited government. In your mind, what are other critical tools enshrined in the U.S. Constitution that are critical to this principle of limited government?
As Madigan said earlier, I think the First Amendment is a good tool for limited government because it allows the citizens to speak against the government.
A couple other examples would include popular sovereignty, warrants that are required for arrests, the Bill of Rights in general includes a significant amount of specifics.
What I want to expand upon was Madigan's comments that sometimes the greater good outweighs the individual rights. You reference biological and attacks and terrorism. What are can you give me some examples that we've experienced where you would think it would be appropriate to suspend?
I would personally look to the insurrection. Sorry.
Go ahead, you can finish.
I would look to the insurrection on January 6th. I think that is a quintessential example of a time that I feel that there should have been some sort of step in order to handle this situation.
All right, and it's time. Yay. Good job. All right, now we're going to do some feedback.
Well, deep breath, everybody. Really good job. I thought this is a very technical discussion. I thought you had a very good grasp of the writ itself and the evolutions, starting us off with why that England was returning to a monarchy after 11 years after following the English Civil War, and how they felt it was important to have some restrictions on the king. I liked how you talked about the founders, and then you brought us forward to 1863, and then the KKK under Reconstruction, and ending, and then weaving us into modern times with Guantanamo. And I thought your references to the issues we think about today, terrorism, biological warfare, if we did have a situation like that in this country, would it be okay for the executive to suspend habeas corpus? I thought you showed a strong and nuanced grasp of the issue. So the only thing I regret is that we did not have more time. I had about 5 more questions for you, to explore these concepts with you. So thank you for sharing your conversation with us. I really enjoyed it.
I concur with my colleague. I really wanted to get more into, you mentioned the Geneva Convention a couple times. I wanted to dig into that more, but alas, we're out of time. I really like the opening of your prepared statement. Just taking us briefly through that British origin, I think is so critical for the conversation around the writ of habeas corpus. So really enjoyed that. Thought that was a great place to start. Really thought you laid out that nicely. We only hear this once, so having a well-organized, well-prepared opening statement is always critical, and I think you guys did a nice job there. Just really enjoyed our conversation. Everybody got in there. You clearly were able to put some thought into this and wrestle with some difficult questions. I really enjoyed our conversation.
Well done. Now, here's what I liked. I liked that you focused on how it was so powerful, the writ of habeas corpus. And then when we pushed you, you kept coming back to the First Amendment as support and as strengthening your primary argument. And in my opinion, and what I teach is it's the First Amendment for a reason. That's why it's the first. And so between the writ of habeas corpus and the First Amendment, we have some tremendous rights and some tremendous power. So what I liked is how you kept intuitively and overtly coming back to that fundamental basis and the intertwining of the two, because that shows a certain level of sophistication and understanding of the subject matter. So I appreciated that. Well done. Congratulations. Thank you.
Thank
All
you.
right.